Go ahead and call the meeting back to order. Sheila, the floor is still yours. Next item of business is discuss an act on budget amendments for the fiscal year 2015.
I should have those in your packet. First one should be interdepartmental transfers. These are department heads that have asked for transfers from one line item to another within their department to cover overages, which is always recommended. The second page should be your certification of revenue. The largest one there on top, $30,963.88. That's the Department of State Health Services Health Project. That's money that comes in usually monthly. Sometimes I'll get behind and I'll get 2 or 3 at a time. So I just try to keep up with that certification on the budget. And then various miscellaneous things, donations, refunds, additional supplement on the county judge, transfers. The next page is just the Department of State Health Services detailed out for you, which matches the certification amount. And then your fourth page is the remaining budgeted, remaining expense line items. Do y'all have any questions on those? They're all standard.
Sheila, this the $30,963.88, I want help. Is that grant
Yes.
that Carl works under?
Yes.
Right.
And this is where it's been approved for again, or what?
Yes, sir. Every month, one of my staff members prepares a report, and we send it in to the Department of State Health Services, and they refund us based on our expenses. So I don't certify it every month. It's cumbersome to do it that way, so just every few months. But that amount reflects our expenses and reimbursements for February through June.
Okay.
14,948 is a contractual. What is that?
It's ETMC. 99% of that is contractual work to ETMC.
I make a motion to approve these budget amendments.
Second. We have a motion by Commissioner Worsham, seconded by Commissioner Chamberlain to approve the budget amendments as presented. Any discussion? Not all those in favor signify by saying aye. Aye. Those opposed? Hearing none, motion passes.
It was a pretty short meeting, one for the auditor, wasn't it?
Who's this back? Next item of business on the second page, item 16, is review and act on approval of county auditor's quarterly report of fee collecting offices.
Your first item there is your cash reconciliation. We still have some items in transit on the state quarterly reports for December, March, and June from the Treasurer's Office. The State Comptroller quarterly reports, there's 4 reports that are submitted every quarter: criminal, civil, specialty, electronic filing system. Because these reports are due, you have 1 month after the cutoff of the quarter months for the reports to be filed. They need to be submitted to my office before they're transmitted to the Comptroller's office, because as soon as they're transmitted, that is an authorization for payment. And I need to be able to review these before they're transmitted, and that's not been done. The reports always have at least, one or small thing on them, always. So it's just always been the best practice to get those to me in a timely manner, which is required by the government code. On the monthly reports, there's no exceptions on any of the monthly reports, except that the county attorney has some checks that are outstanding that are old that I think they're continuing to work on. He's gotten that number down quite a bit. There was quite a few of them. Now it's just down to 5 checks. All the constables have reported in this quarter from all 4 precincts. Your cash counts, there was the list there where there were no exceptions, and then we have a few offices that had a few small exceptions. The tax office in Trinity had an overage of a quarter. The tax office in Groveton has overages that are attributable to the difference in the tax statements that they receive. Many, many times have 2 or 3 cents higher, and so this is just an accumulation of that. If it's more than $2 or $3, the tax assessor will refund it, but JP 2 and 3 both had small overages, and then the county treasurer's office had 2 shortages. And that's my report.
Motion to approve.
Second.
Have a motion by Commissioner Chamberlain, seconded by Commissioner Smith, to approve the auditor's quarterly report on fee collecting offices. Any discussion? Not all those in favor signify by saying aye.
Aye.
Those opposed? Hearing none, motion passes. Next item of business is discuss and act on personnel action forms.
This is just a summary of all of the changes that have occurred per the policy, to bring them to your attention. I have the individual ones if you have questions, but otherwise this is just the summary if y'all want to read over that. If you, let me know if you have a question.
Make a motion to approve.
Second.
A motion by Commissioner Smith, seconded by Commissioner Brown, to approve the personnel action forms as presented. Any discussion? Oh, just sign somewhere there on it. Okay.
Sheila, you gonna go sit down there?
I am. I'm done.
Or at least for a minute or two.
No discussion. All those in favor signify by saying aye.
Aye.
Those opposed? Hearing none, motion passes. Next item of business is the district clerk. Discuss an act on accepting certification of the county auditor's reappointment and order to pay.
If you please record, Kristen's out. She asked me to.
Yes, ma'am.
This morning. On August the 7th, both the district judges get an appointment of the county auditor for a 2-year term. In the order, it asks that the district clerk's office hereby certify this action to the court and to include the order in the minutes of the Commissioner's Court. That's what I was here to do. And the appointment is from August the 7th, 2015 through August the 7th of 2017. Signed by both the judges, file stamped in the district clerk's office, signed by Kristen Rayford and Shasta Bergman. If you have any questions, well, otherwise it's just basically a formality to put it in the minutes.
Okay.
Don't need a motion.
Need action on that, Mr. Bell? Is that just presentation to the court?
Technically, yeah, you go ahead.
I make
Okay.
a motion with
Second.
approve.
Have a motion by Commissioner Smith, seconded by Commissioner Worsham, to accept certification of county auditor's reappointment in order to pay from the district judges. Any discussion? Not all those in favor signify by saying aye.
Aye.
Those opposed? Hearing none, motion passes. Thank you, Ms. Kathy. Next item of business is discuss an act on approval of the receipt file listing, specified activity report, and payroll register. Mr. Dawkins, the floor is yours.
Don't have one.
Good morning, gentlemen.
Don't have one.
What I would like to do is, before I make the presentation of my report, which is our standard reports, I want to bring to y'all some good news. Money. The check is no longer in the mail. We have received our Forest Service money for last year. The check, the amount that we received was the $202,658.11. What I would like to
202-668?
202-658.11.
Is that all ours, or are we splitting the school?
Split it.
We split it. Half goes to the schools and half goes to
County.
county, broken up on y'all's precinct percentages. But what I would like to do is, I think we have a budget workshop.
Yes, sir.
I'll bring the recap of what we received in the first check, recap of what we've got right here, let y'all look at it so y'all maybe can do a little better job on planning your budget for the next year.
Okay.
So that's the good news. Well, this is not bad news. In front of you, you have this listing.
Actually, only the judge, I think, has it.
Only the judge has
I don't think I have one either.
What is it?
It's,
It's the activity
It's the
report,
payroll-
payroll register.
Right here it is. It's hidden under here.
Oh, in the bottom. Yeah. In the bottom, sorry. It was up on the bottom of it, yeah.
Oh, a check register?
Yeah, it shows the payroll checks, then our receipt file listing.
I think Sandra stuck it on your desk.
It's underneath.
The first page is just the listing or the total that we have for the net payroll checks for the month of July. 2 payrolls, 1 extra check, the $125,654.87. There's the detailed listings attached to support that. I think the next item of note is it's headed up, specified activity report, July 1 through July 31, 2015. Looks like this. That's an important report that shows how much money that the county took in and how much money the county dispersed in the month of July. Also has the ending bank balances for all the accounts.
And that number is?
$1,603,512.21, but that's somewhat of a misleading number. That's not our general fund or our operating funds. That includes other funds. I know for a fact that our INS fund is going to drop. I think the payment was $187,000 or something on those notes. So probably the most important number I think that y'all need to keep an eye on is the very first line item, which is the general fund. And then you might drop down and see the 4 road and bridge funds. Those are the most active funds that we have in the county.
Old precinct 3 is the lowest one, ain't it? Shows you're doing something.
Doing a good job.
Spending money anyway.
That's right.
Got anything else, Bob, on these reports?
That is, well, there's the listing of the savings accounts is the next page. That's really basically it. Last page is just our fixed asset listing. That'll change a little bit, I think, this next month. We've got 1 or 2 items falling off of there.
Make a motion we approve this payroll register and activity report. Second.
I have a motion by Commissioner Worsham, seconded by Commissioner Brown to approve the reports listed or reports recognized. Any discussion? Not. All those in favor signify by saying aye.
Aye.
Those opposed? Hearing none, motion passes.
Thank you, gentlemen.
Thank you, Bob. Next item of business is discuss and act on rules governing the operation and regulation of alarm systems in Trinity County, Texas. The sheriff asked that this be put on the agenda. Sheriff, would you like to address the court as why we need this on the agenda and what?
Well, it's like we discussed last time, we have a lot of
Yes, sir.
alarms that are going off repeatedly, and they're false alarms. We're sending officers. Most recently, we've sent one like 12 times to the county line from here or the other side of this county of Trinity to a bar out there that got an alarm, doesn't have it registered. We can't get hold of the key holder. We have to run out there every time. We're wasting money. We're wasting gas. We're wasting time with an officer. I don't know what Joe Bell found. I didn't get a chance to look at it. You were
I got you 2 years ago,
yeah,
sir.
well, it's been 2 years ago. I haven't looked at it. I didn't prepare for this today. However, whatever he recommends, I'm assuming, I think we need to have my opinion is I think they need to register it with us. Too often we're getting alarm calls that just gives you a house number in a street. 90% of the houses in Trinity County are not numbered. They can't tell us who the alarm belongs to. They can't tell us who the house belongs to. They can't give us a key number, a description of the house, and they can't give us a key holder phone number. So basically, these companies are just selling these people these alarms, not getting any good information from them, and just charging them $30 a month for the
Alarm system.
for the
Maintenance and
monitoring, and they're not doing a very good job of it.
Yeah.
So my suggestion is, I don't necessarily think we need to charge any kind of fee, but I do think that it needs to be registered with us. We need to have an application that these people bring to us and say, we're going to have an alarm at this address, this is a key holder, this is everybody's information on file. And I do believe that if we go out there more than 3 times on a fake call, I think they need to start paying us. It would be a lot less for them to fix the alarm, but a lot of people, because there's no repercussions, there's no one saying you need to fix this, or there's no penalties for it.
Right.
They don't, because they don't want to spend the $50 or $100 to get the alarm fixed.
Right.
And instead, it's at the taxpayers' backs to have us having to run out there over and over and over. Do you want to go from there?
Okay, we'll start. The system I worked up, basically same one they use in Harris County or Montgomery County, is based on state law. My understanding of the law is if it's registered, the alarm's registered with the state, we can't require them to register. But almost none of them are registered to the state we have. You know, like if the school district or somebody has their own alarm system, we can't make them register. But if we can require them to get a permit, and that way the sheriff's office will have the information on that alarm, and we need to set up an application system, which won't be difficult. We just use the forms they use in other places, and they just change the name to Trinity County Sheriff's Department.
Okay.
I don't know if we want to do a fee or not. That is paperwork the sheriff's office will have to take care of.
We could do something minimal, $10, something like that. I don't want to break anybody, but then again, if we can't service them if we don't know where the alarm's at.
Right.
On average, how many false monitoring calls do we get?
Sir?
On average, how many false alarm calls do we get?
Yeah, I didn't get the numbers. It's quite a few.
No, it's more than acceptable number.
Yeah, I mean, it's way out. Like I said, we run them more than 12 times out there, and I finally called the owner, got a hold of him, and I said, I will not send a deputy out there no more. I'm not doing it. You either get your alarm fixed, or don't call us, have it call somebody else. And they got their alarm fixed. But I shouldn't have to make a phone call.
Business or
This was a business.
Yeah.
But we have a lot of homes too. The homes are the hardest thing to find. The business, we know where it's at. The homes are the hardest thing to find. As you know, houses are not marked. People do not mark their houses in Trinity County. And a lot of these subdivisions are places, there's no rhyme or reason to some of the house numbers. And, you know, we're checking 4 or 5 houses until we find which house it is. And if it is an emergency, we need to be able to get there right then and not have to check 5 houses. We need to be able to find that house. And this would probably coach people into marking their house properly as well. I think that needs to be a requirement. You're going to have an alarm, have your house marked.
I think it wouldn't be unreasonable, like the sheriff said, if it's repetitive, you know, you could
Well, the
do a number.
state standard is after you had 5 false alarms, you start charging them every one after that. And I think it's basically $75 per call. And then after they get a certain number, and I think the number is 9. False alarms, you revoke their permit.
Unless they're
That's fine, man.
unless they're registered with the state, and then the state, anything the state does supersedes anything we do.
Yeah, but we won't be dealing with many of them anyway.
Does this exempt us from any liability of responding after the 9 and they don't fix it? Or is there even any liability anyways?
Well, there is some liability, but it don't exempt us either. You know, definitely we have to enforce it.
Right.
Okay, so you got 9 false alarms, you need to give them notice you're gonna revoke their permit. They get it reinstated when they fix the system.
So if we pass this right now, it would start over, it would start, right, when we pass it.
Well,
Woody would have to keep.
Well, we're gonna have to get it up and running. What I suggest you do is you, pass it preliminarily, and then we'll get a permit system set in, and then you approve the permit system.
Do we have to do a public hearing, Mr. Bill?
I asked the judge's office to put it on the agenda for setting a public hearing for the next meeting, because you might want to speak to the issue. I don't know what they would say, but they might want to speak to the issue.
I would encourage the judge in his letter from his desk to, and I think he's already done this one time before.
On the addresses? On the addresses, got it, yeah, I can do that, yeah.
Put a house number on there. That's very important for ambulance or any emergency vehicle.
True.
Yeah, you have to, most cities require it, the house numbers.
So,
There's not a requirement in the county. I mean, you can't put a requirement and make them do it, right?
Not that I remember, but I'll look into it.
Well, I'm not going to be far enforcing it, making them do it, but I'm just saying you can encourage people to do it for their own safety.
We need to encourage their own safety.
right,
There's a lot of issues that go with that.
right, exactly.
Okay, so my suggestion is we pass this to set up the system and then come back to the next meeting and put in the permit system.
Now, does that include like the life alert bracelets and all this? Is that the same kind of deal?
I don't-
We've had a couple life alerts that we couldn't find. Took a while. And that to me would be more important than anything when somebody falls and can't get up.
I don't know if
Be
we,
able to find them.
I don't know if we can do
I
that.
don't know about, well, maybe we just try to stress these people more and call life alert or something, but I'm not saying charge them. But I am saying that they would at least call us and say, hey, this is where I'm at, this is my house, this is my address, I marked my house. That would create, or keep some confusion from happening as well.
No, we have, the new systems they have are GPS activated and they don't go to their house, they go with them wherever they go with a little bracelet.
Okay.
The problem with that is dealing with the ambulance. You get a call, a life alert, and you get out there, 9 times out of 10, they're locked up in there asleep with that thing around them, and they rolled over and punched the button. They don't even realize they're rolling. You can't even get them to come to the door, and you fool around out there very long, some people, you might get your head shot off, you know. So it is a real problem, these life alerts.
Doors too, for people laying inside the house, couldn't get up. So that's what we do, but we don't want to go kick in the wrong house either. Yeah, that's where it's a shot.
True.
We think Miss so-and-so lives here, and she really lives down the road, and we kick in somebody's house, door, thinking we're doing a good deed, and somebody gets shot. That's not good.
So what do we need to do here, Joe?
Well,
Yeah, see,
I asked to set a hearing on this, but it didn't get on the agenda as setting a hearing. So,
As long as we're making progress and we're addressing it, I'm good with
So
that.
you're recommending passing this and coming back with a public hearing on the per meeting?
yeah.
Okay.
Well, you can go ahead and vote on this. Authorize the sheriff and me to set up a permit system and set up the alarm system.
Okay.
Second.
Have a motion by Commissioner Smith, seconded by Commissioner Chamberlain. Any discussion? Any more discussion? Not all those in favor, signify by saying aye.
Aye.
Those opposed? Hearing none, motion passes. Next item of business is discuss an act on setting a hearing and posting notice thereof to discuss reopening Old Sulphur School Road from Sulphur Creek Road to its end in precinct number 1 of Trinity County, Texas.
Old Sulphur School Road won't go away. I talked to Mr. Bell the other day. We voted to accept that road, but it hadn't gotten posted out there. So after the meeting, Mr. Sharp posted, and I've got the pictures where he's posted it. And Mr. Bell recommended that we go through the procedures again since we kind of got the cart ahead of the horses on it. But since then, I hadn't got to visit Mr. Bell about it. We had a meeting the other day with the lawsuit we've got going on in another area of the county, and I informed Mr. Bass with Allison and Bass and Associates that done our county road map about Old Sulphur School Road and was kind of inquiring about how to get it on our county maintenance map. And he said what we done probably was not legal, that we needed to get a dedication from the landowners first out there before we done what we done.
Well, yes and no. I don't
Well,
think
it
so.
just depends who you talk to, Joe, and I'm trying to do it right, you know. I appreciate your info and I always relied on you, but after Mr. Bass told me this, I got a little bit nervous about it, doing it, if we done it right and everything.
I'll run through this again. At a school out there, common school, and a road going to the common school. When they closed the school, it still belonged, it's Centerville got the property. It's their property. The road going to their property, you can't close it because it's a public entity. You cannot adverse a public entity. Now, you can close the road if you fence it up for 20 years, but you don't close it to the adjoining landowners unless you block them, but you can't block the school. So that road was not closed to that property until they sold it to the private owner. And it hadn't been fenced up long enough to run against him, statute run against him. So he has a private easement on that road. Though, if he wants to dedicate his private easements to us, that's
Well,
cool.
it won't be a problem because the landowners have already agreed to dedicate the road to the
We can
county.
do the paperwork.
Here's what I suggest we do, that go ahead and set this hearing again, and let you get in contact with Mr. Bass, and y'all talk about it, because I did not discuss the fact of Mr. Bass that used to be a school down there. He was under the impression that it had been abandoned for more than 10 years, and the reason that we didn't do it right. But I did not tell him that there used to be a school down there, so why don't we set this hearing, and I can get y'all together in a conversation, and they can bring a recommendation back to us when we do the hearing.
You making it in the form of a
Yes,
motion?
I am.
I'll second.
Do we need to set a date for that hearing?
Yes, sir.
September.
You gonna do it at the second meeting? You gonna do it first meeting or second meeting?
Well, we can set it for the 14th and have the hearing that day.
Okay,
Then you can decide whether you want to act that day or not.
That'd be fine.
okay. I have a motion by Commissioner Worsham, correct? Or Commissioner Smith, seconded by Commissioner Worsham, to set a public hearing, post notice thereof to discuss reopening Old Sulphur School Road.
I'm gonna try to get in the meantime with the two landowners involved and get in writing their dedication of their land
Okay.
to
Dedicated easement.
dedicated easement.
That would be length and width.
Yes.
A quick question before we vote, Judge, in a discussion area. Tiger and I talked about sulfur being spelled S-U-L-F-U-R, like it's been on the maps for years and years. Is that somebody's last name that's specifically spelled that way, or are they talking about?
You know what I told
the
you,
mineral
Rich?
sulfur,
The Yankees
which is
spell it
PH.
PH and the Southerners spell it F, you know. Whatever the correct, I mean, it makes no difference to us or the landowners out there, I don't
When we
think.
passed this a few weeks ago, I thought it was an opportunity to get it right, so we notified TxDOT
Yes.
of an additional county maintained.
Whatever the correct spelling of it is.
Spelled it PH and.
Yes. I'd say whatever's on all of our, so we wouldn't have to change it. I mean, I don't know. It makes me no difference, and it makes the landowners no difference out there.
Just remember, you're the only one from the north, Rich.
But I went to first grade in Mobile, Alabama.
All right, if nobody has any more discussion, well, all those in favor signify by saying aye. Those opposed? Hearing none, motion passes. Next item of business is discuss an act on setting a hearing and posting notice thereof to discuss changing the name of Hunter's Drive to Trinity Cove to Hunter's Lane at the request to the Trinity Cove Property Owners Association and posting notice thereof.
The real reason for this action, recommended action, is that in the 9/11 addressing process, they discovered that there's two Hunter's Drive. There's one there, and there's one in Precinct 3 in a development, I think, called Colony Park. Trinity Cove has a improvement association or property owners association. We weren't sure if Colony Park did, so we thought it'd be more expeditious to have Trinity Cove property owners approve that change rather than trying to get it done without a POA at Colony Park. We simply need to have the public hearing and decide if we can make that change as a group of county commissioners. From Hunter's Drive to Hunter's Lane, leaving Hunter's Drive on the map in Colony Park. But it is driven by the 9/11 processing system or addressing system, whereby the state doesn't want any duplicate road names in a given county. So there's several of these we'll have to deal with down the road, but this one in particular came to light in the last couple of months, so that's where we're at. Pardon? I need a motion.
Set that hearing on the 14th also?
That'd be fine.
Okay.
So moved. Are you making a motion? I made it.
Jimmy
Okay,
did.
second.
I have a motion by Commissioner Brown, seconded by Commissioner Smith, to set a public hearing, post notice thereof. Public hearing date will be 9/14. Any more discussion? Not all those in favor signify by saying aye.
Aye.
Those opposed? Hearing none, motion passes. Next item of business is discuss or receive updates on the following projects and discuss an act where applicable. County Energy Transportation Reinvestment Zone Grant Road Improvement Projects, $350,000 CDBG Road Improvement Grant Opportunity, and Hurricane Ike 2.2 Grant Funding and Project Status.
Okay, we filed our last CTERS reimbursement request last month, so we are in essence done with the CTERS projects. We'll take that off the list in the future so you don't have to put up with it.
Okay.
But that was a real boon to the county in getting additional rock on several county roads in all 4 different precincts. The $350,000 Community Development Block Grant opportunity, grant opportunity, is in the hands of Ray Van and Associates now. We did our preliminary work in the last month or so to identify one project in each precinct that we'd use the money for based on the normal allocation that we normally apply to funding and so on. So it'll be some time before we hear, but the application is in the mill. It's being reviewed and commented on by Klotz and Associates, the engineers we used for the Hurricane Ike project, and they have done their part and forward that to Ray Van. On Hurricane Ike 2.2, I think, Mr. Smith, you said you've got a few more loads of rock this week, or are you done?
They are finishing me up today.
Okay.
The mine is completed and they're moving the grader and stuff over to Precinct 4. to Finish his up.
You still have some Hurricane Ike stuff?
Oh, yeah.
Okay.
The mine will be complete today.
Okay.
They starting on mine.
And Tiger, I'm not sure where you stand. Are you done with Hurricane Ike?
I've got to get with Russell and we put our tickets together and make sure that we're balanced and then
On the rock part?
on the rock part, yeah.
Okay. And I think I've got 11 or 12 loads that still due me that I've got to apply as part of the Hurricane Ike funding. The other part of that funding is the paving of 5 roads, 3 in Precinct 2, 1 in Precinct 4, 1 in Precinct
Two in precinct.
2 in Precinct 1. CCC Construction has moved their equipment into Precinct 4 to begin there, and then they're going to come back and work their way along 356, which has the other roads that are part of that project. I explained to the CCC that we sure would love to have all of that Hurricane Ike stuff done and finished in this fiscal year, which means the end of September. He said he thought that was a possibility. Now, again, depending on weather and so on, we'll see. But I think the goal is to try to get that all done before the new fiscal year starts. That's my report.
All right. Nobody has anything else?
A lawyer pointed out to me a couple of weeks ago in the courtroom, he says he thought there was a mold problem in the ventilating system because it looked like there was mold accumulating around the vents in the courtroom.
Okay.
I don't know if that's true or not, because I'm gonna go climb up there and look.
Yeah, I know Mr. Jesse and his staff have cleaned some residue around some of the vents. I don't think it was mold, I think it was just accumulation of dust and
dirt.
stuff, but
Yeah, mud.
we can definitely look into it, sure.
Well,
So,
I just wanted y'all to be aware of that possible.
appreciate it, so.
That's not on the agenda, Mr. Attorney.
I know, I'm just telling you. I don't expect you to do anything about it.
Mr. Bell is here, Tab Bell is here to give an update, and I didn't get him on the agenda, but if it's all right with the court, we'll move back up into public forum. He's just going to give a presentation to the court, no action required, of what delinquent tax collections look like and where we are and what we've done or what you've done.
Thank you, Judge. This would be just a status report, no action, so it fits within the open forum of the Commissioner's Court. I will say that I was a little bit late coming in this morning. First day back to school for a lot of folks, and I've already seen a car wreck here. Elkhart, y'all know on 155 coming into Elkhart, you turn into the high school, and there's another car coming from the opposite direction. They had a fender bender. Nobody hurt that I'm aware of, but an excuse for being a little bit late. This is a snapshot of your tax roll. It's as of August the 7th. I get a tape update from Ms. Warren, your tax collector, every month. So this is not as of today. It's as of earlier this month. Your delinquency, total delinquency, which includes through tax year 2014, is 1.9 million. That's fairly high, but a lot of that represents lake lot properties, which is just the same old story we talk about every meeting. You have a couple of interesting things. If you look about the third page of the report, this is what I call an authority activity analysis report. It's kind of, again, the snapshot of your tax roll. The top boxes show the categories of properties. You have roughly 10% of your roll as struck-off properties. That is the stuff we talked about earlier in your meeting, the properties that have been to sheriff's sale, nobody bought them, they're struck off to the school, county, in trust for the benefit of other property owners. Excuse me, for the benefit of the entities. The litigation, we have $317,000 of your tax roll tied up in litigation. We have $324,000 in bad address accounts. That's not surprising to me. 16% of your roll has bad addresses. It's actually a little bit surprising it's not higher because of the volume of lake lots where Daddy bought the property 20 years ago, he's passed away, and the kids have moved on to Dallas or Houston or whatever, and they don't contact the appraisal district forwarding addresses. So it's a lot of money in bad addresses, but I'm surprised it's not even higher. The last category, the action pending, that's kind of the everything else category. That's the category of properties that are not in bankruptcy, not in litigation, not in bad addresses, which is another way of saying the green light accounts that we can go after. And they were all turned over to us July 1st. The middle box shows the accounts by dollar range. I always am interested in looking at the first dollar range, $0 to $100. 46% of your accounts are below $100. It's only 7.5% of your money. The largest percentage of your money is between $250 and $500. And again, if you think of your lake lots, these are not homesteads. Most people don't have a home with a $450 property tax bill. They're lake lots. The good news is you don't have very many accounts that are over $5,000, and I'm going to talk about one of them. None of them over $10,000. So, going back to the first page, the narrative report, as I discussed earlier this morning, we had a sheriff's sale in April, and we sold, for sale, about 1,055 lots. We sold about 70 of them, but the rest of them were struck off, or there was no buyers on those properties. We're looking to try to resell those as we can, and I've talked to Mr. Gallant, your chief appraiser, and we're talking about the possibility of offering them in a block of either 4 or 5 adjoining lots sold as one bid, to maybe even if we can find 10 or 15 in a group selling them all adjoining. I don't know if people want to buy them that way, but just selling them one at a time is going to take years. So we're going to try to find ways to, you may want lot 1, but we're going to make you buy lot 2. We're open to any suggestions, but obviously we're looking at ways to try to sell some of these lots and get them back on the tax roll.
Whatever restrictions is in the subdivision would still apply if you sold them in blocks.
Yes, sir. If there's a deed restriction that says it must have, like a setback of 25 feet from the front lawn, it must have a 3,000 square foot house, which is unusual for this area, but if that was the restriction, we don't cut off the deed restrictions. They're still in place. And we also can't, at our end, change the description of the property. So if it's a 60 by 100 foot lot, which is maybe ideal for a manufactured home, we can't go in there and, well, I guess we'd replat it if we had all of them, but we don't have, like I said, we sell a patchwork of different lots.
Look, this is really handicapping the county and all the taxing entities by these people being able to get away with this. There's no laws in the state law that would hold the developer
Well, there is personal liability. I mean, the property owner that owns property on January 1 of each year is personally liable. But in this particular instance, it was essentially a shell corporation owned by the developer. The only asset was the lots. And when we sold the lots, I mean, they didn't have $100,000 cash in the bank. So, I mean, if I sell your personal property, and you personally own it, you're individually liable. But in the case of a corporation that was set up for the sole purpose of avoiding personal liability, our options are greatly reduced. So we don't have, we legally have personal liability. We don't have any prospects for recovering because the only assets of the corporation were these lots, and when we sold them, they had no other assets that we could go after. But, if Exxon had some swampland, worthless property here, we could go after some valuable oil wells that Exxon has over here and collect on the personal liability. But in this case, these were not owned by the original developer. It was owned by a corporation. And we actually talked to the principals of that company, and they just effectively said, I'm going to waive my investment in this property, and y'all can sell it. They did not want to pay the taxes to keep the lots. So you're right. Our options are not very good, and it does tie the hands of the taxing jurisdictions, but the alternative to selling it is let it remain and just accrue year after year of additional delinquent taxes. On the plus side, by foreclosing them, until we sell them, they remain exempt from this day forward until sold, and so you're not accruing year after year of future year taxes that are never going to be paid. So I'm stopping the bleeding, in other words.
Okay.
And you try to take something out of being a subdivision and put it back into undeveloped land or something like that. It's a pretty involved process, unless you have the developer cooperate with you and the property owners association agreeing to it.
I'm not sure if the property owners association, if they would consent to it either. In an
That's
ideal
one of
world,
the big problems.
I could see you getting a lot of pushback from that.
in an
Yeah.
ideal world, they want people to buy properties out there and have,
Since all of these developments have been done, Commissioners Court, prior to me getting here, has changed the guidelines on
More than
how to
once.
put in a
Yeah, we've done it
subdivision. So this is not probably going to happen anymore.
We can hope so. We've got more and more strict over the years of making developers more and more accountable. But we still have Eagle Falls, which is
Problem is, what happens is you kind of get, my experience being up here, you get kind of crucified of not wanting, if you don't hold the developers to what they say they'll do, or if you get real strict on it, then people say, well, you're not for growth. You're trying to make it so difficult on these developers but that's not the case, because we know by experience, these developers are going to leave, and they're going to leave these landowners with these situations and everything.
We're haggling with the Eagle Falls folks now, trying to get the bond money so that a new developer can continue the project.
the option on fixing these problems if you can get a new developer to come in and take over and redo it, invest the money, so it'd actually be a saleable item. And that's hard to do on some places like Port Adventure's been sitting in a long time without some actual improvements.
And part of the problem here is just the scale. I mean, I've never done a tax sale of 1,055 lots in one suit. 25 lots, 50 lots, a routine developer would not have 1,000 lots available for sale. It's just very difficult to sell that many lots in 1 year. So
I have a question. There was a headline in the Houston Chronicle back in the spring saying, and the big thing was the tax sale at the Harris County Courthouse. And they were talking they're going to change the system of how to do the tax sales. Did that ever float through the legislature?
no, sir. I mean, there's pretty wide latitude for doing resales. We can have a resale and re-offer these properties on the courthouse steps. We've done 2 in the last 5 years here where we have an auction or a minimum bid through sealed bids. You have some success. The idea is you offer on a best offer basis. If somebody wants to bid $25, you'll take it for the sole purpose of getting it back on the tax roll. We can do a public auction. We can do a private sealed bid auction. If somebody comes in, like you approve the bids today and makes an individual bid on a single property, you can approve those. So there is a lot of options or latitude, but it's really more a function of here, just supply and demand. We've got 1,000 lots. How many do y'all want to buy? So if we can create the demand, if they can strike oil out there, or it's supply and demand. The supply is just incredibly large. We also had at that same April sale 90 acres of land, and the property owner at that particular time filed bankruptcy to stop the sale. We got the bankruptcy dismissed, and we sold the acreage at a July sale. And Commissioner Chamberlain was asking about the right of redemption. There's a 6-month right of redemption under Texas law for non-homesteads and non-family farms. So the buyer at this July sale of the acreage has roughly till the first part of January to he's entitled to immediate possession of the property, but the former owner has 6 months to redeem it. But the redemption price would be the $130,000 that was paid plus a 25% penalty. So they're looking at roughly, $160,000 to $170,000 to redeem. And if you had that kind of money, you'd have paid the taxes before the sale. On page 2, I've identified a couple of individual property owners. The number one, and I don't want to mention these by name and embarrass your neighbors. I'm not trying to do that. In the very center column, I've got PBF numbers, which is kind of like an internal account number. So I'll just kind of go top to bottom. But if you have a question about any specific accounts, you can just say, page 3, PBF 123, and that way we can be sure we're talking about the same property on. The top one is a commercial property in the city of Trinity. It's maybe of interest to the Commissioners Court because DebtCog has done some financing on this property. Talked to Judge Page about it. There's also a bank involved, and we've talked to the property owners, so we've talked to a lot of people in this one. We're expecting a 50% payment this week, by the end of the month, and then the balance to be paid in September. So they understand the importance of getting their taxes paid. So I don't think a suit's going to be necessary. And of course, from our perspective, we want to work with the property owners and collect the taxes, not create more struck-off properties for the county. The second one there, it's in the name of the original taxpayer, but this is the Lake Lot development out at Port Adventure that has since been struck off. And it's in the name of Groveton ISD on behalf of themselves, the county, and the hospital district. The third account is a store in City of Trinity that's in bankruptcy. They owned a number of stores across the state. We're a statewide law firm, so we have bankruptcy specialists that participated in this bankruptcy, negotiated as a part of the company's plan of reorganization, payment of the taxes. So we expect to get that actually in the next month or two. The fourth account down is developer at Lake L. I'm not sure if it's the original developer. They just own a lot of
Darrell Hall.
A lot of lots, and they buy and sell lots. It's almost a function of us trying to keep up with the sales they've got, because some of the lots that are delinquent, they will sell them to a buyer, and the buyer not only has bought the property, but they've bought the delinquent taxes. But we are working with them. They're cooperative, and we're happy to cooperate with them, and when they say, okay, well, I sold lot 1 to Billy and lot 2 to Johnny, then we just contact the buyers and work with them. The next account down there, we've been promised payment by the end of the month. I believe this is a cable company. The next one, we actually had scheduled a sheriff's sale on this back in the spring. We stopped the sale in the expectation of a pay agreement. We got a down payment, significant down payment, which is, we're not going to stop a sale for $100, but we did get a significant down payment. We stopped the sale. They made promises to pay the balance in a timely manner. That didn't happen, so we're going to be rescheduling it for a sale. We did wait a little bit of time because the family went through a family hardship. One of the principals of business passed away, so we give them that opportunity, if you will, to get back on their feet. Next to the last page, we've talked to these folks a couple of times. They say they sent us a check in July. It hadn't come in, and of course in Trinity County there's 2 tax offices, the county tax office and then the appraisal district, which collects for the schools. They mailed separate checks. Neither office got either check, so they're trying to check it out, track down what happened. We've talked to them a couple times. We're satisfied they're telling the truth. It's not just checks in the mail. We believe that they're telling us and they're trying to track it down. It was not sent certified, and they've promised they will pay the taxes if they can figure out what happened. In any event, I'm not worried about this one going to collect default. The last one is paid in full, and I just wanted to note that a lot of people on this list are people that haven't paid. This one was paid during the course of this month. In the top of page 2, this is another example of a property owner that has a number of lake lots. They've essentially said, come and get us. We cannot pay the taxes, we can't sell them fast enough to pay the bills, and we're going to just wind up having to take them to a sheriff's sale. Behind the AA roll, which is where I talked about page 3 and 4 that had the different boxes, I've got 2 descending tax rolls. The first one is for 2014 only. They may owe prior years, but this is just the amount they owe for 2014. And I show this just because these are the folks that have just gone delinquent. They were turned over to us in July. I've got 3 pages of accounts for 2014 only. And then behind that, I've got, it's a report for all years. And the one that starts off at page 2 of 7, that shows a number of properties that have been taken to sheriff's sale and they were struck off. The ones that are Trinity ISD trustee, we have a tremendous amount of properties for the Trinity ISD school district that we've taken to sheriff's sale. Most of them at Westwood Shores, and nobody wants to buy them, so they get struck off. We've created multiple accounts here because if somebody comes along and says, I want to buy lot 1, block 2, it's a lot easier to find it in a, quote, small account instead of one that's got multiple, hundreds of lots in one account. So that's why we don't combine them.
Nobody wants to live out there with you.
Good.
Well, and in fairness to the folks at Westwood Shores, I mean, there's 8 or 9 sections out there. The properties up close to the front entrance, those are good properties, nice homes, they sell. One of the former people out there charged a transfer fee, and the country club had a transfer fee, and it was about $1,500 in transfer fees to both the property owners and the club. Nobody wanted to buy a lot and then have to pay the transfer fees on top of that, not to mention the monthly property owner dues. So you have to be a homeowner that wants to live out there, not a weekend recreational, I just want to have access to the golf course sort of thing. And so we have trouble selling the lots in the more remote sections of Westwood Shores. We had some property at prime property locations. They don't even get to tax sale. The property owners pay those. So
That 2 transfer fee had changed when the POA took over.
that's my understanding.
The country
They
club.
made it a little bit more realistic and more manageable. And in the computer era, I mean, let's be honest. It didn't take a whole lot to go on your computer and drop out Rich Chamberlain and put in Doug Page, hit enter, and you save the changes. So $1,000 transfer fee is probably a little bit high in the computer era to do all that. So.
A little high in the old era to do all that.
Well, this, again, was just an informational report to give you all a kind of a snapshot of your tax roll. If you have any questions, let Lindy know. You can contact me. I mentioned the business we had the sheriff's sale on, and we stopped it because of a hardship in their family. That's, these are your neighbors. So if y'all know of circumstance where somebody has a hardship, whether it be medical hardship, employment hardship, let Lindy know. She can call us. We can mark our account so that we don't go after somebody that's in a time of temporary misfortune. Now, somebody's got a 10-year delinquency. That's not economic hardship. That's refusing to pay. But we can mark our account so we don't continue to send letters out to people that are going through a rough patch.
Ted, on the page where it shows from 1976 all the way to 2014.
Yes, sir.
A question. Prior to 2076, is everything knocked off the roll, or is that?
20-year statute of limitations. So basically 1994 and prior, we can write everything off that hasn't been paid. The ones that go back to 1976 are properties that have already been to sheriff's sale and they're struck off. And so those are considered to be in litigation and we don't write them off. But if an individual property hadn't been paid in 20 years, then it's kind of shame on us and we write it off. So the ones that go prior to 94 in time are ones that have already been to a sheriff's sale and they're struck off. And then when somebody submits a bid, we pay the taxes that we can and write off the difference.
One more question. On the next page, let's just pick out 2000. There was 40,675
Yes, sir.
in delinquent taxes for the whole county.
Yes, sir. That's base taxes, no penalty and interest.
And then it kind of just goes up. 03 it was 60, and then it goes to 67. When it gets down to 2009, it jumps to 109,000. 10 was 134, 11 150, 12 192, 13 is 250, and 14 is 396. What is the fluctuation? Why is it so much higher in these recent years?
Combination of things. One, property values are increasing, and so if Johnny goes delinquent in year one, he goes delinquent in year two, and his market value is higher, his delinquency is going to be higher. I don't know if y'all have been increasing your tax rates every year. I suspect not, but that would be if over a 10-year period your tax rates have increased, that would be a factor. In an ideal world, I understand what you're saying. If it's delinquent $50,000 in year one, it should be $50,000 in year two, assuming the same people go delinquent.
But a lot of these cases in the last 3 to 4 or 5 years, people will let them go and then they'll catch them up before they go to sue, right? Some of these, it takes more than...
Well, we would certainly work with the property owners and give them the opportunity to get caught up. And when somebody does have a multiple year delinquency, we'll pay the oldest year first and let them work forward in time. I'm not sure if that answers your question, but I will add this is not unusual that you would see kind of a declining. The further you go back in time, the smaller the balance becomes. That's not unusual. That's typical of any jurisdiction. You're kind of looking at it as the old years coming forward. It grows every year. But like in 2014, somebody has a 3-year delinquency, but they don't all have 20-year delinquencies. So most 3 years recent are going to be higher, and you go back in time, they'll have paid some of the older years. So I guess maybe that does answer your question. The people that are making payments, we pay the oldest year off first.
Yeah. All right, thank you.
Anybody have anything else? Appreciate you, Tab.
Yes, sir. Thank you.
Keep up the good work. So, appreciate you.
Yes, sir.
Steadfastness. We've been in here another hour sitting. Let's take a 10-minute recess and we'll come back and go into our budget workshop. We're discussing act on changes to the fiscal year 2016 proposed budget.